hear from Ms. Carter earlier and to learn everything that she had to offer in terms of the resources and stuff for our young people. So, as we go along, I think it's our moderator's goal that we have a lot more of these type of sessions so that we can have an opportunity to learn things that we don't know about and to enhance ourselves, our lifestyles. So this morning it's my pleasure to introduce Sister LaTanya Rhines. Ms. Rhines is an elder law attorney. She's been practicing for over 20 years. She's a member of St. Minor Primitive Baptist Church in Guntersville. Some of you may have been fortunate enough to hear her. She did a presentation for us during the Women's Congress, and just the information that she relayed to us during that session, we thought it would just be remiss if we didn't at least have a second opportunity for her to present to what I hope to have been a larger group of people. But we are here, and we will take that information that she has for us. As it says in Hosea 4:6, my people perish for the lack of knowledge. We as a people have a ways to go in some areas in terms of things that we need to learn and to understand and put into our everyday practices and things we need to think about. So let's not perish for the lack of knowledge. Sister Rhines is going to bring us quite a bit of information, and I'm sure she will make herself available either directly or through myself or the association by the cabinet if you have questions or anything, if you need additional information or assistance. So at this time, please help me welcome Sister LaTanya Rhines.
Thank you. Good morning.
Good morning.
Can everybody hear me okay? Yes. Normally don't have a problem being heard. Then this week I've been trying to get hoarse. I'm like, oh, wow. Never happened except for what I need sick. But anyways, I appreciate the invitation to come back out. Just thank you. I want to say thank you. I enjoy what I've heard so far. I didn't turn it on. Okay, now is that? Can you hear me now? Better. Okay. Now you can really hear me. So again, I appreciate the opportunity to come back out. As Mother Maston said, my name is LaTanya Rhines. I'm an elder law attorney. I appreciate, she's very kind to say over 20 years. She didn't tell you it's close to 30. Next year will be 30 years. But time goes fast. But I'm just thankful to have been able to continue in this field. And I appreciate the opportunity to share information about estate planning and elder law and those sorts of things. And I especially welcome opportunities to share them among us because it is very important to plan. When you have a plan, you have options. When you start thinking about things earlier, you do have more options as to what you can do, as opposed to waiting until a crisis is upon you. And then when the crisis is upon you, your options are very limited, and usually they're not good options. So I appreciate this opportunity. And what I'm going to do is I'm going to talk to you about some basic estate planning. I'm going to start with wills because that's what most people are familiar with. But I'm also going to touch on trust. I'm going to touch on deeds. I'm going to touch on powers of attorney. I'm going to touch on medical directives. So hopefully you'll see how all of this ties in together, because when I say estate planning, there are many things that go into having a good estate plan. It's not just one thing. There'll be many times people say, I got a will, I'm good. Like, well, do you have anything else? Nope, I got a will, I'm good. Like, okay, that's a start. But now let's talk about some of these other things. And you'll see why that's so important later. Now, I'm one of those people that I know some people like for you to hold your questions to the end. That's not me. If you have questions, please feel free to stop me. If I go too fast, people say I talk fast. So if you want me to rewind, go back and say it again, I'll gladly do it. And if you have any questions, please let me know. As I always tell people, I say that for two reasons. Number one, your questions tell me what you're interested in, and I want to talk about what you're interested in. And number two, if you're like me, by the end of class, I forgot the question. So just go ahead and stop me and say, hey, I'm going to ask you right now. So I'll start with wills. Now, a will is what most people are most familiar with. It's just a basic document that you have prepared. And that document pretty much says, this is what I want to happen to my possessions after I die. And this is the person that I want to oversee how those possessions are distributed. Very simple, very basic. Making a will is really not complicated, and it has one of the lowest levels of capacity as far as having documents prepared. What I mean by that is, as long as you know what you own, as long as you know who your family is, basically, and you know what you want to do with your assets, then you can make a will. You have to be 19 or over in the state of Alabama, and your will has to be in writing, has to be witnessed by 2 people, and it's best if it's notarized, because if it's notarized, it's a self-proving will. And basically, you can decide to do whatever you want to with your assets for the most part. It's yours. You can give it to whoever you want to, except if you have a spouse. You don't get to just say, my spouse gets nothing. I'm cutting my spouse completely out of the will. Doesn't work that way, because if you do that, they can go back and elect against your will sometimes and take part of it anyway. So now, sometimes if you've provided for your spouse elsewhere, then you may not need to leave anything to them in the will. But just know that your spouse, that becomes a little tricky if you decide that you don't want to leave anything to them. Now, sometimes when you have a couple, they will have what's called a prenuptial agreement, and that can be an exception to having to leave assets to your spouse. And when I started practicing, I said, well, I won't have to worry about those. That's for those rich Hollywood couples that have all this money and they're not going to stay together, so I won't see those. But I was wrong, and I'll tell you where I used to see them. A lot of times you might have a man who was widowed. You might have a lady who's widowed, and they decide they want to get married. And she says, I want to marry you, but I want everything me and my first husband accumulate together to go to our kids together. He'd say, you know what? I feel the same way. I want everything me and my first wife accumulate together to go to our kids together. That makes sense, doesn't it? So what they can do is they'll sign an agreement and say, okay, we're going to say before we get married, whatever you had before we got married is yours. You can do whatever you want to with it. I won't claim it. And whatever I have is mine. I can give it to whoever I want to, and you won't lay any claim to it. And if we accumulate anything together, we'll decide how to divide that. So if a couple does that and they sign something after full disclosure, then you're not obligated to provide your spouse with anything you had prior to the marriage. Now, by full disclosure, before you can do that, one side has to tell the other side everything they own. You can't tell them that all you own is the pickup truck and you forgot about the $100,000 in the bank and the house in the other state. You got to tell them everything. But if there's full disclosure, then you can do that. Now, in addition to our spouse, who are the other people we typically want to provide for? Our children. The spouse and children are what are called the natural objects of your bounty. That just means those are the people we normally leave our possessions to. And most of the time we want to leave them to our children. Now, may be times when a person does not want to leave assets to a child. And unlike a spouse, you can disinherit a child, but you want to make sure that you do it the right way. The wrong way is just not to mention them at all and pretend they don't exist. If that happens, then that child could contest your will, because what they may say is, you know what? Mother and daddy left something to everybody else. They just forgot to put me in there. It was the lawyer's fault. They didn't list me. They meant for me to get something. And since they're your children, the assumption is, well, it probably was just it's probably just an oversight. So let's give them something. The problem is, if you've left everything to 3 of the 4 children, and that 4th child comes in and contests the will, and the court says, okay, they're going to get something too, your estate doesn't get any bigger. It's just that those other 3 children that you wanted to have the assets don't get as much. So it could really affect your estate plan. So if you're going to disinherit a child, you want to make sure you do it properly. First, people may say, well, why would anybody want to disinherit a child? I saw lots of reasons. Sometimes people say, I love my child, but my child has a drug problem. Or my child has a problem with gambling or whatever it is. And I know if I give them money, what's going to happen to it? It's just going to facilitate the problem. It's going to be gone. Some people say, I love my child, but I've done more for this child than I did for the other kids. I helped this child buy a house. I bought them a car. I paid for them to go to college, and I didn't do that for my other kids. So they've already gotten their inheritance. Some people say, I love my child. I hadn't seen my child in 20 years. I don't know where they are, believe it or not. I would see that. Sometimes they just become estranged, and parents, some would say, I don't even know what her last name is now. We no longer have a relationship. And then some people would say, my child's doing a lot better than me. They don't need anything I have. I'm going to leave it to the grandkids or somebody else. Whatever your reason, that's fine. But what you want to do is at least acknowledge the child in your will. How do you acknowledge it? Some people will say, I'm leaving them $1. I'm leaving $10. Or they'll say, I've intentionally chosen not to make any provisions for this child under my will. But you've at least mentioned them, because then it makes it hard for them to come back and say that you just forgot about them. So just keep that in mind when you're making provisions for children. Also, when you're making provisions for children, think about, you're planning for the now, but you want to think about the future. If you are leaving something to a child, and this would apply to a grandchild too, and I'm going to talk a little bit about grandchildren in a minute. I was trying to decide if I should wait till then, but I'll go ahead and say it now. If you are leaving something to someone who receives means-tested government benefits, they have Medicaid, they have other benefits where they're only allowed to have a certain amount of resources, be very careful about leaving something to them outright. Because if you just leave it to them outright, then what you leave to them could count as a resource. And if they're over-resourced, they could lose their benefits. Most of the time when we leave assets to people, we do it because we want to help them, not hurt them. We don't want them to lose their insurance or their Medicaid or their benefits. And the thing about it is, when you leave a person a gift, you can disclaim. You can say, no, thank you. I don't want it. I appreciate the sentiment, but I'm just going to reject this gift. But a person who's receiving certain benefits, they can't do that. If they do it, it's called a transfer. That means, okay, you gave away something you were entitled to, so now you're going to lose your benefits anyway, or you're going to get penalized. And so what happens is they end up getting put in a difficult position. So if there's a situation where you're leaving something to your adult son and he's on SSI and Medicaid, what you may want to do is look at leaving his assets in something called a special needs trust or supplemental needs trust. And I say these things because when you sit down to make your will, when you talk to the attorney, let the attorney know these sorts of things, because then they can advise you on how to set up your will, how to leave, who to leave your assets to. You want to be very straightforward with them. You want to be very honest. You know, I tell people there's a way we wish things were, then there's the truth. And I mean, if we're just honest about it. And, you know, when we make our documents, we have to make them based on how things really are, based on the truth. You know, wouldn't it be great if you know, all of us wish that all the kids got along. Nobody ever, I heard that, they don't. Nobody ever argued. The grandchildren were all respectful, and they were great money managers. That's not everybody's reality. Right. What world is that in? So when you make your documents, you have to know those things. You know your family better than anybody else. And the other thing you shouldn't assume is that just because you're gone, they're going to automatically change. So if you know that when you sit down with the attorney, let the attorney know if this is the child that you don't want to inherit. Let the attorney know if this child is disabled, or it looks like this child's going to be receiving benefits. Let the attorney know if this person is going to have trouble managing assets or resources, because then they can help you to devise the best estate plan. Because most people, when they come in to have their wills and their documents prepared, they're doing it because they want to take care of the family members they're leaving behind. They want them to have assets. They want them to be able to manage it. They don't want to see what they've worked for all their lives just squandered or dissipated. And so that attorney can kind of help you to devise the plan, to set up a plan that's going to help you accomplish that. Does that make sense? So share information, share the good, the bad, and the ugly when you go in and talk to them, and let them steer you in the right direction and along the right path. Now, yes, sir. Okay, right.
Well, with a will, if you don't have a will, insurance, people have life insurance, you got beneficiaries. How should or should not you handle that with will? For example, you don't have a will, but I got an insurance policy, got beneficiaries. How do you deal with that?
Okay, that's a great question. So they'll take me to the next part of my. No, you just told me where to go next. So I like that because I was debating. No, well, no, that's good though because I'm like, well, shit, no, that's perfect because that leads into the next section. Now, you remember when I said a will is how you determine who's going to get your assets after your death? Sometimes it's how you determine who will get some of your assets. There are some assets that will not be distributed under your will. We call those non-probate assets. One of the non-probate assets is a life insurance policy if you have a designated beneficiary and that beneficiary outlives you. In that case, the will doesn't control who gets those assets, the contract does. And most of the time when you have a beneficiary, it's good to have a contingent or an alternate beneficiary in case that beneficiary dies before you or you die at the same time. Then again, that money still is not distributed under your will. Also, if you have a house and land and that property is jointly owned with another person with right of survivorship. If you have it's called joint tenancy with right of survivorship. If you have a survivorship deed, if one person on that deed dies, the property automatically goes to the survivor. It does not, your will does not control what happens to it. Most husbands and wives, especially if they've been married for a long time, if you take a look at the deed, that's how they own the property. And if you want to know if it's survivorship, just look to see if it has the language for their joint lives to the survivor. If that language is on there, again, if one dies, the property automatically goes to the survivor. Will, doesn't matter what the will says, it's going to go to the survivor. Or, now, it's important that that language is in there. Don't just look at the deed and say, because it's got two names on it, that, oh, okay, I'm good, it's got me and my spouse. If one dies, it's going to go to the other. No, if it does not have that survivorship provision, it is just a joint tenancy in common. That means if one dies, the survivor still owns their half, but the other person's half is going to be distributed according to the will. So read your deed, read your document, make sure it says, has that language in there if that's what you want. And then there's a deed called a life estate deed. And a life estate deed is the type of deed where maybe you've got a person who's widowed. And that person say, well, I want my kids to have my property one day. I'm not ready for them to have it yet. So that person can go ahead and deed that property to their children or whomever they want and reserve the right to live there for the rest of their lives. And then at that person's death, that property automatically goes to those kids or whoever they deeded it to. It is not controlled by the will. So none of those assets pass under your will. Those are called non-probate assets. In addition to those deeds and the life insurance, if you have a bank account and you have another person listed on that bank account, please, if it's a true joint account, the bank can pay all the money in that account to the other person. And, so if you've got your oldest daughter on the bank account and your will says, I wanted my 3 children to get it, the bank can pay all that money to the oldest daughter. And if she wants to share it, hopefully, but she's not, there's no obligation there. The bank can't be held liable. Let's just say that the bank's out of it at that point. Or if you have what's called a POD, that's a pay on death provision on your bank accounts. And that's very popular and it can be very useful, especially if you don't want your money tied up in probate after your death. Because if you have a POD, it's just like putting a beneficiary on a life insurance policy. You're putting a beneficiary on your bank account. You're saying, now, the good thing is, we'll talk about this with powers of attorney in a moment. That person, that's not their money while you're living. And they can't do anything with that money while you're living. But at your death, then the bank will pay that money directly to them. And it's not distributed under the will. It doesn't go through probate. And you don't have to wait to get those funds. That might be on checking, it might be on savings, it might be on your CD, and you don't even have to go through a lawyer to do that. You go through the bank and you fill out the paperwork. If you have a transfer on death provision on anything, or a beneficiary on anything, an annuity, an IRA, on stocks, anything that has a beneficiary on it, and that beneficiary outlives you, it's not going to be distributed according to your will. It is a non-probate asset. And any assets you have in a trust, and we're going to talk about a trust again a little more detail later, but assets that are in a trust, a living trust, those assets are not distributed under your will. So you take all those things out I just talked about. Somebody might say, well, what do I have left? My clothing, my furniture? Then that's what's going to be distributed under your will. So if you think about the situation I just described, doesn't that sound like a husband and wife? Everything's owned jointly, right of survivorship, beneficiaries jointly. That's why a lot of times when the first spouse dies, the survivor doesn't have to really do anything. They don't have to go through probate. It's because everything has passed to them jointly. Now, does that mean that if you're married, you don't need a will? No. Because number one, you never know who's going to die first. And number two, you could die in a common disaster or accident. Exactly, both of you. So it's good to have these things in place. Still have your will, but you can have all these other things in place too. These other things basically override the will. And assets that are distributed under the will, in order for them to be distributed, for title to change on them, is they have to go through probate. Is there anybody here that just ready, just wants to go through probate? You just can't wait, right? You just want your estate to go through. Now, probate is necessary to determine who the rightful owner is of the assets, but it's not going to happen overnight. You're going to most people hire an attorney, then you have to file the will, you have to notify all the, Mother Master's like, I know all about it. You have to notify the beneficiaries under the will, you have to notify the certain relatives, then you have to, once you get it admitted, then you have to run that notice in the paper for so many days, for so many weeks, and then after that, you get that 6-month waiting period. And if there are any creditors, if you owe anybody, guess who gets paid before your beneficiaries? Your creditors. And there's an order that they get paid. Some get priority over others. So then after all that's done, then finally you get around to distribution, if there's, of what's left. So needless to say, it can take a while. Sometimes it might take, if you're lucky, 9 months, a year. It just depends on how. I've seen estates in probate for years. Yeah, right. So much decades. For years, because especially if it's a complex estate, if you've got somebody contesting it, you got somebody challenging it, or you're trying to locate a beneficiary, it can slow things down. And it can cost money because, you hire an attorney to guide you through the probate process. And then there are fees you pay associated with probate. So I'm not saying probate's a terrible thing. In Alabama, it's not as bad as I've been told it is in other places, but it's still time consuming and it can cost money. So non-probate assets are a good alternative, especially if you have the opportunity to do these things that I've mentioned. It's just something, it's good to know. It's good to have the information. Of course, the final decision is up to you, and the final decision is based on what's right for you and what's right for your family. A lot of times we talk to friends, and friends will give us well-meaning advice, and that's great. But when it comes to making your own estate plan, you need to sit down with somebody and make a plan that fits you. I used to tell people, if you've seen one estate plan, you've seen one estate plan. One size doesn't fit all. And, sometimes people say, well, my neighbor did this and it worked for her. But then you're married, you've got kids, you've got grandkids, your neighbor, she's widowed, she never had any kids, she doesn't own a home. So what she does is going to be different from what you probably need to do. So again, planning ahead is so important. So did that answer your question? Okay. But it's a good to start. This is the time to make the decisions. Now, speaking about making a will, everybody says, well, we have people come in and they say, well, I'm getting older, so I figured I need to make a will. And that's a good thing. Yes, we do need to think about that and make sure that we've got things in place. But the person who needs a will more than anybody else is a person who has minor children. So if you have children, grandchildren, tell them don't wait. And the reason I say that is because, a lot of times we'll talk about the will. We think about, okay, yes, it's important to determine who's going to get what, who's going to be in charge. But the most important thing you'll ever do as a parent when it comes to estate planning is you will nominate a guardian, name who you would want to raise your minor children if anything happened to you and their other parent. That's so important, because when the time comes to determine who's going to be a guardian or who's going to have custody of the children or raise the children, there's so many factors that have to be looked at. And if you've got family members on both sides wanting to raise the children and nobody has anything in writing, you can imagine the result may not be what you wish for it to be. But when you have somebody nominated in writing, that person usually rises above other people who might be in consideration. And again, when I say you know your family and your situation better than anybody else, you know how you would want the children raised. You know who's going to take care of the assets that you leave them and make sure they're not squandered. You know who's going to have the same values that you have that you want to impart to those children. So it's very important that you make sure you have a say. And I say that because not only, I say that a parent with minor children, if you are a grandparent, our previous speaker talked about a lot of grandparents raising grandchildren. Some have custody, some have adopted them. Very important, again, to make sure you've thought about and you've nominated somebody to raise those children in case you can. And if you're going to nominate anybody for anything we talk about today, whether it's your executor, guardian, power of attorney, make sure you talk to the person first. Okay. I mean, you just think about it. I mean, you wouldn't want to just find out surprise. Your power of attorney, your guardian, you want to talk to them because you want that person to, first of all, agree. And then that person, you want to be able to share with them what your expectations are. And then it's an opportunity for them to ask you questions as to what your expectations are. So, you don't ever want to just, I've practiced for a long time. And sometimes people would be like, let me think about, well, I guess I can name my cousin. I hadn't really seen her in about 20 years, but, we get along. There's no animosity between us. I'll think, but you need to check, I would say check with her first. So, and that's all part of your planning, part of your estate planning. You can come into the attorney can do the paperwork, the attorney can give you advice, they can give you guidance, but then you have a little homework to do too. You've got to make sure that what assets do I own? Have a list of your assets. Who do I want to do these things? Have I checked with these people? How are my assets titled? Those sorts of things. Those really help when you sit down to make that estate plan. Yes?
I wanted to make a statement about when you were mentioning assigning a guardian for minor children and how, you want them raised and someone's going to take care of their assets and their funds. So the person that's taking care of the assets and the funds doesn't necessarily have to be the same person.
Oh, great point. Great point.
Guardian might be good with money, but they will raise your child like you want to.
That is such a good point. That's a great point. In Alabama, you have guardian over the person, which we call guardianship. Then you have a guardian over the assets, which we call conservatorship. Or sometimes the assets may be in a trust for the child as a trustee. Right. The guardian, the person over the child's health and well-being does not necessarily have to be the same person who manages their resources or assets. And that's very important because some people are great. They're nurturers, they're caring. They're going to make sure your child gets to the doctor. They're going to make sure they go to church. They're going to make sure they have what they need in school, but they're just not good at managing money or finances. And they'll tell you. And you've got the other person over here. They may not be the nurturer, but boy, they can account for every penny that's spent. And so that's why it's so important for you to make the plan because you know your family, you know who you can trust to do those things and who's going to make sure the children's assets are not only there, but that they're used in the way that you intended for them to be used. And they're going to be used for the benefit of the child. So that's a great point. Great point. Any other questions so far? Yes, sir.
Trust. How does trust work? Who needs a trust? How do we need to work out the trust? So I don't have to go through probate.
Okay. Now, a trust, it is a legal arrangement that you can set up. It is an alternative to a will. Sometimes it can be a companion to a will. Sometimes it can be contained in a will. But basically, a trust is an agreement where you determine who certain assets are going to, you put assets in the trust for the benefit of someone else. You name a trustee, that's the person that's going to manage the assets. And then the person who puts the assets into the trust is called the settlor. So you got three main parties, the settlor, the beneficiary, the trustee, and the beneficiary. Now, there are different types of trust that you can set up. One type of trust is called a testamentary trust. Now, testamentary trust is actually set up in your will. You might have a will and you're leaving assets to a child who's very young, and you say, I don't want them to get those assets, until they get to be a certain age. So in my will, I'm going to say I give, devise, and bequeath all the residue and remainder of my assets to my grandson, so-and-so, or to so-and-so as trustee for my grandson. And then you have everything set out in the will pretty much about the rights and responsibilities under that trust. The thing about that is, in order for that will to be legally enforceable, the will has to be probated. So a testamentary trust is probably not going to get you, to avoid probate, but that still may be the way you want to go. Most of the time when people talk about trust, they're talking about living trust. If you hear the term inter vivos trust, it just means a living trust. That's one that's established during your lifetime. And when you make a living trust, you can set it up as a revocable trust or an irrevocable trust. A revocable trust is one that you can go back and change. You can amend. You can terminate it if you want to. You can take assets in and out of the trust as the person who set up the trust, as the settlor. An irrevocable trust is just like it sounds. Once it's set up, it's done. You can't go back and freely take things in and out of that trust. You're pretty much locked into it. And there are benefits to both. Sometimes you want a revocable trust. Sometimes you need an irrevocable trust, depending on what your purpose is for setting up the trust. Now, one of the most important things to remember when setting up a trust is it's not enough just to set up the trust. You have to fund the trust. That means the only assets that the trust controls at your death are the assets you actually put into the trust. You have to deed the property to the trust if you want the trust to control it. The trust can own the property, just like you did. If you've got other resources or assets, you have to actually make the trust the owner of those resources. Sometimes a person will have a trust and they might want to put the house in the trust or put some other asset. They want to put everything in the trust. They may say, I want to put my car in the trust. I'm probably going to, sell it in a few years. I'm not going to have it that much longer. So you don't have to put everything in the trust, but just keep in mind, the only assets that do not go through probate are those that are actually in the trust. And most of the time when a person has a living trust, they still have a will. And what they'll have a lot of times is what's called a pour-over will. And that pour-over will is just like it sounds. It takes anything that you owned at your death that maybe you didn't want to put in the trust or didn't have time to put in the trust, it pours it over into the trust. So everything is controlled by the trust. And again, with the trust, the person that manages things is the trustee. You can have a successor trustee if you wish to. And a trust, unlike a will, when I say you probate a will, when that will is probated, you record in the probate judge's office. It's public. A trust is private. Nobody knows what's in your trust. It's not something you can go down to the courthouse and see. So there are a lot of reasons a person may want a trust. Primarily, some people may say, well, I don't want to go through probate. I don't want my assets to go through probate. It might be a situation you're leaving assets to somebody who's very young, and a 7-year-old, even a 17-year-old, you don't want them to have all this money at once. If you think about it, I can speak for myself. My judgment at 17, my judgment at 19, which is the age of majority, no, it wasn't what it should have been. Even in my early 20s, still had a lot to learn. Even when you think you know it all, you still got a lot to learn. And if you think back, do you think you would have made the best money decisions? Some people would have. Some people are just more mature. Some people are not. Again, what do I keep saying? You know your family and you know your situation better than anybody else. And sometimes it's not always the maturity of the person you're leaving it to. You don't want other people coming in, talking them out of their assets or money. I can tell you, I used to see instances where people, especially if they were really young, when they had money, they had friends. Those friends that came around until the money was gone. And then what happened when the money was gone? The friends were gone too. They didn't mind helping you spend it. And it wasn't always an inheritance. It can just be, So again, those are the kinds of things. Sometimes it's to protect the child. And just sometimes it's just about growing up, until they're mature. A lot of times people say, well, I want them to have this money when they're 25 or when they're 30. This will be good for them to maybe help them get a house, or it's money for them to help, And sometimes they may say, I want them to get it at age 25 or 30 unless they go to college. Then if they go to college, this money can be used to help pay for them to go to college. So again, what a trust does is a trust really offers more flexibility. And that's the way I look at it. It allows you to, there's some things that you can put in a trust. You have more control over what happens with those assets, how they're managed, even after your death, than you do in a will. When a will goes through probate, it's going to be in probate for a certain period of time, but then eventually it's going to close. And your executor, eventually they're going to say, okay, when this will closes, hopefully I'm through my responsibilities. But that trustee, that's going to be an ongoing thing. And so you have to think about, I tell people, think about what it is you want. It might be, that person might be trustee. If the children are very young, it could be for a long time. That's why it's important to have successor trustees. You can also specify in the trust when that trust terminates. Does the trust terminate upon the death of the last person that set up the trust, of the settlor? Does it terminate upon the death of all the beneficiaries? Does it terminate when the funds are depleted? Again, you get to specify all those things. And that's why when you sit down with somebody to make your trust, you want to talk to them about why is it you're making the trust? What is it you want to accomplish? Yes, sir.
It may be named. I've heard executors, I've heard trustees, or they the same, or what's the relationship between executor, trustee, will, trust.
Okay, great question.
Right.
Y'all don't think we're working together, right? Because he's giving me some good, no, he's leading me some good points. Okay, very good point. Now, with a will, the person who is in charge and manages everything, the person who makes sure your wishes are carried out and makes sure everything's taken care of with your estate under the will is the executor. Or if it's a woman, sometimes they call the executrix. We used to just say personal representative, but it's basically the same thing. That's the person you nominate in the will, and the court has to officially appoint that person when you offer the will for probate. If you do not have a will and you have to open an estate without a will, they usually call that person the administrator or the administratrix. Again, appointed by the court. The trustee is the person who is named in a trust, and the person, the settlor, the person who sets up the trust, names that person, and that person doesn't have to be officially appointed. So their roles are very similar, but it's very important to realize that there are distinctions and their titles are different. Yeah, and whether exactly, and whether it's executor, administrator, you don't have a will, but it's executor, trustee. It's always good to have an alternate or a successor too. Some people have joint executors. Some people have co-trustees. That can be good. I always say, I always encourage people when they were trying to choose an executor, if you're going to choose two people, you better make sure they work well together and they get along together, especially with powers of attorney. I'll talk about that in a minute. But sometimes there's a good reason, especially if you had a blended family, a husband and wife. One would say, well, I want one from one side. I want my son and his daughter. And that way both sides are represented. And that's fine. You can do that. That's allowed. Same thing, you can have co-trustees. But again, it's just very important. You want to choose somebody who is going to not only carry out things the way you would want them carried out, but somebody who has the capability of doing it. If you've got somebody that's just not organized and they're going to get flustered every time something comes up, you want to rethink that. And you want to give it some serious thought. That answer? Okay. Any other questions so far? Yes, sir.
Yes, ma'am. I'm trying to, in my experience, I always looked at this type of conversations kind of like long-term planning, but I guess you can never tell. But I have a little bit of experience with like property deeds, and I'm hearing more about trust.
Mm-hmm.
And it sounds like trust is a loophole to get around probate. But are there any benefits to going through probate?
Benefits to going through probate. Yes, there could be. One, it depends on the size of your estate. If and let me say this: not every will has to be probated. What I used to say is, I used to call it the quick test. I'd say this is the quick test. Is there anything that you own at your death that is valuable and title has to be changed over on it? That's just in your name. If the answer is yes, you're probably going to go through probate. And usually it's a house, it's land. It could be a lot of money in the bank if your name is the only name on the account, but that's usually where you're looking at probate. If you don't have any land, or you've got beneficiaries on your bank account or joint owners and all, if the only thing you have that's going to be distributed under your will is your clothing, your furniture, your jewelry, you don't necessarily have to probate the will for that. As long as all the beneficiaries can get together and agree and follow the will, then you don't necessarily have to probate it. But yes, there could be some advantages. Going through probate again, it establishes definitive ownership of the assets. If you've got property, you have to go through probate to get that deed changed over if it's just in your name. Yes, I don't want you to think probate's an evil thing and that you don't ever want to go through probate, because sometimes you need to. Sometimes, if you're probating the estate, again, it's a way to enforce the provisions that are in the will. Does that make sense? And you talk about long-term care planning. That is a discussion in and of itself. But deeds, trusts, those play a very important part in long-term planning, especially if you're talking about possibly having to go into a nursing home and pay for a nursing home care. You want to have that discussion and do that planning sooner rather than later, because that is one of those things that if you plan sooner, you got options, and you got sometimes some pretty good options. If you don't plan and it's right on your doorstep, that emergency comes, your options are going to be more limited. So while we're talking about trust, if you're applying for, you're going to a nursing home and you're applying for institutional Medicaid, that's the program that pays for long-term care in Alabama, the only one other than long-term care insurance, then you have to spend your resources down to a certain amount. And it's not a lot. You have to have $2,000 or less in countable resources if you're an individual. And when you say what counts as a resource, anything you own, anything your spouse owns, doesn't matter who brought it into the marriage. Doesn't matter. And you know what? Prenuptial agreements don't work for Medicaid planning. And they say, I don't care if you said that what's yours is his and what's his is yours, and we're going to count it when we start to make that division. So, however, assets that are in a trust will not count if it's the right kind of trust. If it is a revocable trust, they still count. You know why? Because Medicaid will say, hey, you can go back and take those assets out. You still have access to them. You still have control over them. So sorry, it counts. If it's an irrevocable trust, then those assets, they're not counted as a resource, but you had to have transferred them into that trust at least 5 years before you needed long-term care. Otherwise, they're not going to take them from you. They can't. They just penalize you on it. And during the penalty period, they just won't pay your room and board in the nursing home. Then there's a third kind of trust, which is very near and dear to my heart, that fits into that discussion, which is a special needs trust. Now, that's a little different. A special needs trust is one that's set up for the benefit of someone who is disabled. And if you've got somebody that's going into a nursing home, the beauty of that is, instead of spending everything down up front, let's say you got $100,000, you sold your home. Well, you got to spend that down to $2,000 or less if you don't have a spouse. So that means instead of having to spend $98,000 paying the nursing home, paying for your room and board before Medicaid will kick in, you can put assets into that special needs trust. And then those assets are set aside for you. You can still qualify for the benefits if you meet all the other requirements. But that money is set aside in case you need other things, in case there are things that you want. You might want, believe it or not, Medicaid only pays for a semi-private room in a nursing home. Hospitals figured it out a long time ago. We have private rooms, But, you know, most people, if you had a choice, you'd rather have your own room, wouldn't you? You wouldn't, if you've got to be there, you don't necessarily want to share a room with somebody else where you're just separated by a curtain and you don't really have any privacy. So you could, you're on Medicaid, Medicaid's paying for your room and board. You could use the money in special needs trust to pay the private room differential or to pay for some other things. There may be some things that you want to do that you don't have the money to do anymore, because when you go on Medicaid, you get to keep $30 a month for your personal needs. That's less than $1 a day on a long month. You get to keep $30 a month. They'll let you pay your Medicare insurance premiums. If you have a spouse, your spouse might get to keep some of your money. It just depends on how much your spouse's income is, but they have spousal allowances. They'll allow you to pay the premium on one supplemental insurance policy. Then anything you have left, you have to pay that to the nursing home. That's called your liability amount. And then Medicaid will come in and they'll pay the difference between what you can afford to pay and the actual bill. So if you have $1,000 left over and the bill is $7,000, you pay $1,000, Medicaid pays $6,000. Great thing is you don't owe anything from month to month. But the other thing is you don't really have any money at $30 a month. So, and the $2,000 in resources they let you keep. So that's where a special needs trust can be great, because if there's some things that you want to buy, you can use the special needs trust to do those. Now there has to be a trustee or a representative. The reason I say it's very near and dear to my heart, if a person is over 65, and believe it or not, let me back up a little bit. When I say there's that period, Medicaid will penalize you if you transfer something for less than fair market value within 5 years, there are some exceptions. And one exception, you could put assets into a special needs trust for the benefit of a disabled person, and the person going to the nursing home can be that disabled person. It's a first party trust. They're transferring their assets to this trust for their own benefit. And if that happens, if they're over 65, it has to go into what's called a pooled trust. The good thing about pooled trust is you don't have to have a trustee who has to know how to manage a trust and how to file a tax return and how to do all these things. A pooled trust, it's almost like, I guess, a mutual fund, you'd say. Is that what you call it? Everybody has their own individual trust, but they're pulled together for investment purposes. It's run by a nonprofit. They have staff that take care of the heavy lifting, and you have a representative, and that representative applies to the trust if you need money for things. And it can be a great thing. We have something here in Alabama called the Alabama Family Trust. If you want to know more about how pooled trust works, you can Google it, look it up. Look up first party elderly trust, and it'll give you a lot of information on how to do that. And it could be a real benefit to the person that sets it up. Yes, sir.
One question.
Sure.
How could we, what do I need to do if I want to leave something to the church?
To the church? Okay. You can leave it to the church either in a will. You can leave it to them in a trust. You can also leave assets to the church in a trust if you don't want it to go through probate. I've seen people even do an insurance policy and make the beneficiary. It just depends on what you prefer. If you want to go through probate, if you're leaving an amount of money to the church, then that's going to have to go through probate most likely. If it's a certain amount, you have what are called small estates. But if you put it in a will, if you put it in a trust, it doesn't go through probate. Your trustee would pay. You would specify when the trustee is to pay. Is it upon your death? Is it 5 years after? But with the trust, you have that flexibility. And let me say something. When you mentioned executor, administrator, trustee, these are all fiduciaries. That means these people are held to a higher standard of and trust, and they are supposed to do things a certain way. They're supposed to do them. Again, they're held to a higher standard. And so if you specified something in that trust, that trustee is there to carry out the mandates in the trust, whatever the trust tells it to. So those would be options for you if you wanted to do that. I think, and sometimes people will they might leave money to a family member and say, I want this money to go to the church. Just make sure you trust that family member to do it. And I don't say that sarcastically. I say, when you leave something to somebody directly, Like I've had people say, well, I put this money in the bank. I want it to go to a church or a charity, but I put my daughter on it as beneficiary. She'll do what I want to do with it. She said that she doesn't have to. Just make sure that you trust her to do that. And, there could be some other pitfalls there. She may do it, but what happens if she dies before she can transfer that money over? So sometimes you go down these, you have to think the what ifs. But again, usually a will, a trust is a good way to do that. A trust could be, especially if you're looking at doing a trust for other things, for other assets. Does that answer your question? Okay. Yes, ma'am.
I got a question. I own a house and I have no children, and I'm thinking about putting my house on trust
Okay.
so that when I pass away, my nieces will know what I want to do or how I have set aside the money. I don't even expect them to keep the house. There's a lot of upkeep on the house, but if you sell it and then how to distribute the money. But I'm thinking about putting it in a trust. Is that a good idea?
It just depends on, the answer to everything is it depends, right? It just really depends on your situation. If you want the house, you want to put it in the trust. The first thing is what type of trust? Do you want to be revocable or irrevocable? Do you want to be a situation where you put the house in the trust and if you decide later you want to sell it, do you want to be able to get it back out? You might say, look, I'm going to sell it. I want to use the money to go into an assisted living and pay for an assisted living or independent living or something like that, or I may want to move to another state. But if you've got it in an irrevocable trust, your hands are kind of tied. So the first thing is to decide how much flexibility do you want? What type of control do you want to maintain? If it's a situation where you're saying, look, I'm going to live in this house for the rest of my life. I don't plan on moving. I don't plan on going anywhere. You might think about doing a life estate deed, deeding it to them and reserving the right to live there for the rest of your life. As things usually stand, if you have a life estate deed, if you have the home in an irrevocable trust, and you have to go into a nursing home and apply for institutional Medicaid, as long as it's been 5 years since you set that up, usually that asset, that's usually not counted as a resource, so you don't have to sell it, and Medicaid doesn't take a lien on it. But and again, even if it's not 5 years, people used to say, well, I want to set it so they can't come and take my home. They won't take it. They'll just penalize you. I mean, we won't pay your room and board. If you transferred let's say, a property worth $140,000, and you go into a nursing home, Medicaid will basically say the penalty. The way it works, they'll say, well, if you hadn't transferred that house, that would pay for the first 20 months of the nursing home. So we're not going to pay your room and board for the first 20 months, but after that, we'll start paying. So that's how the penalty works. And again, if it's in a revocable trust, it still counts as a resource. And in that case, they could make you sell it or, something. But again, that's why it's so important to sit down and have that individual conversation, because you want to talk about, well, what are your expectations? You want it, if you put it in a trust, are you going to say, well, we'll leave it in the trust until it sells. The trust will be responsible for paying for the maintenance and upkeep on the property. Or is it something, if you think it'll be a while before they sell it, or do you think they'd sell it outright? Because the fact that you want it sold. Sometimes I'll have people say, well, I want this home to be there as a family home, for anybody who needs a place to stay. So sometimes, so all of that factors into whether or not you want to put it into a trust or whether you want to do a deed. In that case, if you do a will, it's going to go through probate. So that's probably what you probably don't want to do it in that case. But, and again, the fact that you said you don't have children and you have nieces, that's very important, because when people don't have children, then usually the question is, well, who do they want their assets to go to? And you want to be sure that you specify who that is. You might have nieces and nephews, but all nieces and nephews are not the same, or not created equal. You might have that niece that's like a daughter that does everything for you, takes you to the doctor, comes over, makes sure that the yard is taken care of. And then others that you don't see but once every 2 or 3 years. So again, but there's no right, that's a good thing about, there's no right or wrong. It's about what you want. And estate planning is about you having some control or say over what happens to the assets and the resources that you worked so hard to accumulate during your lifetime. What happens to the children and the grandchildren that you care so much about? That's what the estate planning is about. So these are great questions. Any other questions so far? Yes, ma'am.
What happens to a person that goes to the nursing home and they put a lien on the house?
Oh, thank you.
And that person passes away.
What happens if
If
the,
that person passes away,
Mhm.
then how does the family retain that house and do everything like
Oh, okay, if there's a lien on the property?
that? Yes.
Uh, Medicaid, there's a lien that they can put on your property while you're living. And then my understanding is even if that lien, and that's in case the property sells while you're living. Basically what Medicaid says, we'll go ahead and put you on Medicaid, but then if your property sells, you're gonna have to pay us back up to what we paid for your care at that point. Then at that person's death, my understanding is that particular lien, I think it goes away, but Medicaid in Alabama has what's called a state recovery. A state recovery means that after you're dead, Medicaid can come back and recover against your estate. And remember when I was telling you about those creditors earlier? And there's an order. Guess who's part of that order now? Medicaid is part of that order. It's in the state. They can come back and recover against your estate. The good thing about Alabama is they recover against your probate estate. Remember, your probate estate are only those things that are going to be distributed under your will. At least that's my understanding, unless they've changed it in the last few weeks. But really, they recover against your probate estate. So the thing is, if you still have that home and it's just in your name that you're dead, and Medicaid comes back and they engage in a state recovery, if your family wants to keep that property, then they would pay the lien. They would pay that money off. And then, because that's really what's going to happen. Medicaid don't really want the house. What they want is they want the house sold. And when that house is sold during the probate process, because what happens is when you have assets and you go through probate, and I said all your bills have to be paid before anybody gets anything, if there's not enough money in the estate to pay the bill, then assets are sold and the bills are paid. And so in that case, if there's this lien, there's this property, then the home would be sold and the lien paid off. But if family members wanted to pay off the lien, then they could do that. Does that answer your question? Any other questions so far? Okay. And I will tell you, when you talk about trust, I can't stress the importance of funding the trust. I had a situation one time where a lady, real nice lady came in. She had a trust and she was like, I'm good. She said, her husband had passed away. And she said, I just want you to look over my thing. She said, but I'm good. We had a trust. Somebody that knew set it up for him. And so I'm good. I don't have to worry about anything. So I started looking at her paperwork and I said, when were the assets transferred into the trust? They weren't. All she had was an unfunded trust. So she still had a home. She still had other things that they thought the trust was going to take care of. But since they didn't, and I don't think they even had things jointly owned necessarily. So now she was going to have to go through probate. Even though she had the trust, it didn't do her any good. It's just an unfunded trust. So again, talk to the attorney. A lot of times when the attorney sets up your trust, they'll go ahead and transfer assets. You'll probably get like a trust booklet, but that's good. It's got all the documents and stuff in it that you need. Trusts are more complex forms of estate planning, I will tell you. And when you have a trust prepared, it is generally going to cost you more than a will. Trust can be, somewhat expensive to have prepared, but the thing you have to do is say, is it, it's going to be, if it's going to be worth it, it may be worth that investment just to make sure that everything is set up the way you want it and you're not going to have any problems down the road. And I'll tell you, when you get into Medicaid planning, very, very important. You want to make sure that you've got things set up the way you want them set up. And again, everything comes down to what do you want to happen with these resources after you're dead. Some people, believe it or not, I would have people that come in and say, I don't care. I'll be gone. I don't care. I'm just going to do a simple will, leave it to the kids and let them worry about it. If that's your philosophy, then that, again, there's no right or wrong. It's just that different people feel different ways. But just make sure that you communicate with the attorney, the person you're working with, what it is you want to accomplish. And they'll help you set up the right documents to accomplish that. I just can't stress that enough. Yes, certainly.
Won't answer for everything, but in terms of making a will,
Mhm.
you know, they got these online deals, they got attorneys, you can do your own. What do you recommend? I know it's based on proper how much assets you have involved, but what would you recommend? You just trigger them and you say, okay, I don't know about that.
Okay. And I'm a lawyer, so of course, I'm going to say, if you can have an attorney, prepare it. But I don't say that because I want you to pay lawyers a lot of money. Yeah, I just retired from a dollar. And I just retired from last year. It's been almost a year. Next week will be a year. I retired from an agency where I worked for 25 years, and I prepared those at no cost. So I'm not saying that because I want you to go out and pay lawyers a lot of money. But again, if you've got a complex estate plan, then you want somebody that can sit down and help you do it. Now don't get me wrong; these forms have come a long ways than when I first started. We just had the same one boilerplate language. It didn't matter what state. You can get pretty much state specific, but and sometimes if you don't have any other choice, you can't afford it, or you can't get an attorney or get it prepared. It can be and you need it immediately. It can be a good resource. You want to make sure you got something that said Alabama, because every state's laws are different. And you want to, again, if it's a simple estate, some of them will walk you through it. Some of them even say a will for a person with no children, a will for a person with children, a will for a person with a spouse and children. So whatever your situation is, you want to try to find something akin to that. But, as I've heard said, people say, well, some people may be comfortable preparing their own taxes. Some people may not. And so how complicated, the same thing. Are you, it comes to medical, are you okay? You feel comfortable, I guess diagnosing yourself, I don't know. But we do it, don't we? But so again, if that answers your question, they can be useful, especially if it's an emergency. But what I used to tell people too, I'd say, when they'd say, well, I did my own, I said, you want to bring it in and let me look at it? And so sometimes even if they prepared their own, I like to at least take a look at it. So it might be that you can take it in, you might just say.
Range for simple bill, I know you can't say exactly, $200 to $10,000.
Well, like 10,000, no, you probably have a trust with businesses and all these other good things in it. Right, a ballpark figure. Again, if it's a simple will, probably, I don't know, the cost of everything has increased, probably a few hundred. I had clients that came in that had simple wills prepared. Some paid like $400 or $500. I have a couple that said, yeah, we're going to have to pay $6. Trust, they got get to the thousands. But it's a good enough. So that's good. But again, and a lot of it does come down to how complex your estate is. If you've got, businesses and it can be more expensive.
Are you still practicing?
I'm still licensed, actively practicing. Not really right now. And it's only because I told myself I'd give myself a year. First I said 6 months, and I said a year. So I'm keeping my certifications up. I'm keeping my I'm doing my CLE. So I'm still, a member of the state bar, active attorney. I'm not actively practicing at the moment. I tell you, it'll be a year next week. And now I'm thinking, well, maybe 18 months. My retirement has been great. And I have not suffered from a lack of things to do. But the agency I worked for, they still offer that service. And I don't know who's performing the service. They may be contracting out for a period of time, but you can certainly contact them. The only requirement, you have to be over 60. Doesn't matter what you have in the bank. 59 and a half won't do. You have to be 60. Doesn't matter what you own. They don't look at your resources. All they look at is your age, and you have to live in one of the 5 counties: DeKalb, Jackson, Limestone, Madison, or Marshall. Yes, sir. Again.
You mentioned the statement that the laws are different in different states. Are you familiar with any of the laws that might conflict with Alabama and North Carolina versus Alabama?
The only reason I would say I'm not familiar only because I don't know North Carolina law, and I'm not licensed in North Carolina. So I'm not familiar with what their laws are. Now, the good thing is every county in every state is supposed to be covered by an area agency on aging, and they're supposed to offer similar services. So you might be able to reach out to someone in North Carolina, especially if you have assets or property there, and just talk to them about what the laws are there. But they're just so different. I couldn't even, since I'm not licensed there, I couldn't ethically even speculate on what it is, and especially. And you know, in this part of the state, you get a lot of people that live in Tennessee. We get a lot of people living in Georgia because the region I worked in, I was in DeKalb County. So a lot of times we get people cross over, but even then, being that close, there were just differences in the laws, even Medicaid. And when you go to another state, Medicare, your Medicare is going to go with you wherever. It's not going to, you know, that's federal. But every state has its own Medicaid rules. So if you move to another state, if you're on Medicaid here, you got to get on Medicaid in that state. You got to qualify. So it's, you know, and that's what we would tell people, because sometimes we'd have clients that were looking to go into the nursing home, and they'd come in for long-term care advice. And I'd have to say, these are Alabama rules, because some of them would say, well, you know, I might be going into a nursing home in South Pittsburgh, you know, up in Tennessee or in Georgia. That's where my daughter lives. I'd say, well, if you think that's the case, you really need to talk to somebody about what those rules are. Does that answer your question?
Yes, ma'am. Thank you very much.
Okay. Any other questions so far? Okay. What happens if you don't have a will, or you don't have a trust or an estate plan of any sort? Hello. Yes. The state of Alabama has been kind enough to come up with some laws that specify what happens to your assets if you don't have any kind of estate plan in place. And all I can say is, wow, sometimes it can be very interesting, the result. Sometimes they'll say, okay, if you don't have a spouse, but you have children, then it goes to your children. Unless you have a spouse and children, then this much goes to your spouse, and this much goes to your children. If you don't have children, but you have a spouse, and this is what your spouse gets. If you have a spouse and children, but they're not all your children together with the spouse, then it changes what you get. And then some instances, if you don't have a spouse and children, they can look for your parents. If your parents aren't living, they can look for your grandparents. Then eventually, you know, if you don't have any of those brothers and sisters, but at some point, Alabama's just going to stop looking. And if Alabama doesn't find anybody, usually I don't think they're going to look for your third cousin thrice removed or your fourth cousin thrice removed. What happens is, if you get to a point where there are no identifiable beneficiaries or heirs, that's the word for a person who doesn't have a will, then everybody was saying it. What happens to it? The state gets it. It goes to the state. So, and it's a very simple thing. If you don't do anything else, but just have a simple will in place. You know, you could put a simple will in place until you get the time or the money or the right to do a real one. Like that. Well, it's real, but you have to do a more complex one, or to put your trust in place. Because here's the thing. Just because you have a will doesn't mean you can't do a trust. Just because you have a will doesn't mean you can't do a deed. In fact, all these other things, they override the will. So if you make a will and you do these things later, those things override the will. Anything that's and then your will only covers those things that you know were still there, the things that you haven't already transferred. So what I used to tell people, I would call the will your safety net. It's there just in case. So you got catches everything. Just in case there was something you didn't get put in the trust, just in case there was something that you meant to get around to getting that deed prepared, but you just didn't get to. Your will is your safety net. You got something in place, and then you can work from there and go and do these other things. Okay, now I've got the beneficiary on my bank account. Now I've got this set up and all that. That's fine. It's not going to hurt you. Your will is still in effect, and your will never expires. You can change it or update it anytime you want to. And I encourage people to review their wills at least every 3 to 5 years, because life changes, but we don't always think to update our documents. I used to have people that would come in and they'd say, well, you know, I did my will in 1970. I don't think my 55-year-old daughter needs a guardian anymore. Well, probably not. You know, she was, back then she was 1. So I'm not good at math. she was one or just born. So yeah, life changes. And you want to review it sooner if there are major changes in your life. Major changes are deaths, births, marriages, divorces, buying and selling large pieces of property, because those things could affect the estate plan that you have in place. You don't know it if you have like if you're married and you've left something to a spouse, a divorce negates that gift. If you were not married when you made your will, but suddenly you got married, remember what I said earlier about having a spouse? So you need to go in and look at updating your will. The other thing to keep in mind, I will go back to children. And what I specifically want to go back to are grandchildren. And I say that because, as I said, I would see, and you would see a lot of grandparents who adopt grandchildren. Adoption changes the relationship. When you adopt, that child is taken out of the natural family and placed in the adoptive family. And so now you're not grandmother and grandfather anymore. You're mommy and daddy. You're that person's children. I say that because keep in mind, you might have a will, and your will, and I tell people when you make a will, you want to be as specific as possible. Even in your trust, you want to make things as clear as possible. You don't want anybody to be left having to guess what your intent was, because you won't be here to tell anybody, particularly when your will is probated. And so when it comes to children, I say specify. When you say children, is it just biological children? Is it stepchildren? Is it adopted children? Same thing with grandchildren. Because if you just say children in Alabama, that's going to include your biological and adopted children. It will not automatically include your stepchildren. And again, every family's different. You might have some people say, well, no, I don't really want the adopted child included. I really want it to go to my biological children. And some people may say, you know, my stepson, I've raised him since he was 6 months old. He's like mine. I want him included. You can specify that in the will, but don't just leave it ambiguous. Specify what you mean. And what I say about, I was going to give you the example of grandchildren. Let's say you've got 4 children and 10 grandchildren, and you adopted your oldest granddaughter, I'm sorry. And your will says, I leave each of my grandchildren $2,000 and everything else is divided between my children. In that instance, oldest granddaughter doesn't get $2,000. She gets 1/5 of what's left of your estate. That may have been what you meant. It may not have been what you meant. So again, you want to be very specific and think about what you want and then communicate that when you're having your documents prepared. Yes, ma'am.
Yes, I have a question.
Certainly.
You have property.
Mhm.
The property was owned by 2 people who are already deceased. Another person paid the property tax for the last, let's say, 20 years. Who was the property? Both deceased people.
I see that.
They have children. One person has, all 3 children are deceased. The other person has living children.
Yeah. The reason I saw that smile, yeah, you got those 2 words everybody dreads, heir property. And you want to talk about a nightmare. If you've never dealt with heir property, it can be a nightmare, because in a situation like that, and sometimes, a lot of times that's what you've got. You got one person paying property taxes, but they don't own the property outright. You've got 2 people that died and they didn't have a will, or even if they did, let me just say this, a will, the earliest you can probate a will is 5 days after your death. The latest you can probate a will is 5 years. If you've got a will and you don't probate it within 5 years of a person's death, it's not good. So, let's say this was years ago. So I tell people, even when they have, it looks like they don't have to probate the will, I say hold on to it for at least 5 years, because you don't know, something could come up you didn't know about. But to answer your question, basically, you have to go back and you have to look at the law at the time that the time the last person died, and to see. Well, you look at the time the first person died to see who inherited from that person, presumably spouse, children. Then when the last person died, so you look, most likely it's going to be their children. They had children, so those children became the owners of the property. But when those children's children died, their children inherited their parts. And so you can end up with a situation where you've got a child here, grandchild, and if one of those grandchildren deceased, great grandchildren, all of those people become heirs to the property. And so all of them have an interest in that property. And so if you want to sell it or do anything with it, you have to bring in all of the heirs. I saw a situation one time, and good luck getting two people to agree sometimes. Yes, y'all been there. I'll tell you a situation. A lady I know, this is just somebody in my community, she had asked me to just notarize some papers for her. And she was an older lady. And it was some property in Tennessee. And she was one of the heirs to this property. I think there ended up being like 24 heirs. And it was this little bitty tiny piece of property in one of the, up here in North Alabama, in my home county. And so they wanted to sell the property. 23 people agreed. There was one person, he lived up in Massachusetts. I think he was like 87, close to 90. He said, no, he didn't want to sell it. He might have to come back here and live on that property one day. There's always one. So the odds of that happening were not great, but he had the right to object. So again, when it comes to air property, the frustrating part is a lot of times you have that one person that's taking care of it. They're paying the taxes on it, but they can't do anything with it. And so the best thing you can do, at some point, you're going to have to, they call it quiet title. You're going to have to determine who the owners are and get the owners together and do something with it, whether it's to sell it, get them to deed their part over. One of the sad things you'll find often is, not always, but I found it more often than not, when you get ready to sell the property, everybody wants their part. Even if they hadn't done anything to it, they want their part. Sometimes the person who's caring for it might say, you know what, I'll buy you out. I really want to hold on to this property and keep this property. Because what you don't want to see happen, we talk about transferring wealth and passing it down from generation to generation. You don't want the generation, your generation, or the generation that's paying the taxes to become disabled or to die, pass away. And then that next generation, they don't pay anything. And then it's gone. It's lost for taxes or something. Right, and that happens. That happens because the further removed you get, some of them don't even know they're heirs to the property. Some of them don't even realize it. And so the sooner you can get the title straightened out, the better, because every time somebody dies, you got more heirs. You may have started out with 4, then when this one died, they had 3 kids, and this one had 2 kids, and this one had 4 kids, and now their kids come in. If something happens to them, their kids come in. And that's how you get to those large estates. I was speaking to one group, and a man said he was part of one that had 32 heirs. So again, it just gets more and more complex and complicated. But the thing is, the sooner you can get it, and there are ways to do it. You can ask the court, when you've got a lot of heirs, usually you don't want to partition it in kind. That means you don't want to divide the property up. You don't want to divide the property into 12 different parts, especially if it's not a big piece of property. Usually it's partitioned by sale. That's when you ask the court, okay, let's just sell it and everybody get their part. Does it
pass, is it passed on from one heir to the other? Does it keep going, or does it stop at a point?
It keeps going, and I would say it keeps going. Now, let me specify this. If any of those heirs have their own will or estate plan, they can specify what happens to their part, basically, if they eventually get it. But, right. Well, a lot of times, I would put, sometimes the will, any interest that I own in such and such, such and such. I'm not saying what the interest is. It may not be one, but any interest that I own in this property, this is what's going to happen to it. And that keeps it from, at least that person's part, from continuing to be passed down as heirs. But they really can't do anything with it until the property is sold, the owners are ascertained, and the property is eventually sold. That's why I said air property can be a nightmare. There's a pamphlet, I'm trying to remember if it was Legal Services that put it out. I should have brought some with me. I had used them last year, talking about that one of the greatest contributors to blight and to property, property just sitting unused, is the fact that it's air property, because nobody owns it. Nobody really has a title on it. Sometimes people don't want to put a lot of money into it if they can't use it just for themselves or sell it. Can you imagine if you put all the money into fixing it up and then you sell it and you got to split the money with everybody else? So sometimes people just won't do it. But that's one of the reasons that it's so important to take care of your assets now. And I have a lot of people that come in and say, oh, I've been part of air property. I'm not putting my kids through that. I'm making sure I've got my plan in place because I want at least my kids' part. They're not going to have to deal with that. They'll say, now, if I ever get anything from the air property, fine, it's taken care of in the will. But that's another reason why it's so important to go ahead and have your own estate plan in place.
The person that pays the tax, does that give them any rights over?
I would say you could go back and try to, ask the others to try to get money back from the others. But I don't know that necessarily, it doesn't necessarily give you an ownership right. You're keeping the property, you're keeping it from being sold for taxes. But that would be something I would sit down and talk to, when you're trying to get it straightened out. Say, hey, I've been paying the taxes all these years, and said to the attorney, what can I do towards that? Can I try to get some of that back from the other people? But that doesn't confer ownership on me paying the taxes.
So those heirs still own that part, wherever they may be.
Yes, they still have a part, whoever they may be. And there's a such thing that we learned in law school called laughing heirs. And laughing heirs are people that are heirs to property where they didn't even know the decedent. They didn't even know the person that owned it. They never met him. Might be great-grandchildren. They never met great-great-grandfather. But they entitled to part of the property because it was just passed down to generation. Nobody ever established title and set up the right documents to get that property transferred.
I don't know if this is the case, but even on the law, one time there was thought said people would research the records in the courthouse, who were paying taxes. They would list things that were not paying taxes, and people would go in and start paying taxes. And they said, okay, if they pay tax for so many years, they would own that property. I don't know details. Anything to that?
That's something I'd have to research. I'd have to look at it.
I'm saying that. I'm saying people used to know they got people laying a property that way.
Or just pay it for 15 years.
So I don't know what it was, but I just know that you had a law about that. They researched and said nobody's paying tax on this property, it's called on their own, but start paying tax for over a certain period of time, and they get ownership that way.
Now,
Was that error or anything else?
well, what usually happens if the taxes aren't paid, the property taxes, it gets sold. And they can go in and buy it at a tax sale.
Yeah, but if the taxes aren't paid over a certain period of time.
No, if the taxes aren't paid, usually if the taxes are paid over a certain period of time, if you go, right, if they're not paid, it's gonna get sold and the county's gonna sell it. And then anybody can go in and buy it at that time. You have a certain amount of time to redeem it. But if you don't redeem it in that time, they get it. And I say for little or nothing. And is it 3 years? I think it's 3 years. You have the right to redeem. Now, there is a principle in law called adverse possession. And adverse possession means if you've got property over here and you hadn't been doing anything with it, you hadn't been keeping an eye on it or anything, and somebody else moves onto that property. Some people call it squatters, but yeah, squatters, right. Yeah, they start living on the property or they start using the property. And as long as they use it continuously, they know they don't own it. They're actually using it. Everybody knows they're using it and they're the only ones using it. Then they can come back and claim it through adverse possession and claim title to it. Usually I think it's 20 years unless you're paying taxes under color of title. It's something like 10 years. I have to go back and look, but there's a 20-year and then there's a 10-year, I believe. But yeah, that law is in place to encourage landowners to pay it, to keep an eye on your property, and just don't be an absentee landlord that never check. Now, all 5 of those elements have to be present. I mean, it has to be continual, hostile, actual, notorious, and exclusive. And let me say this, if you're on somebody's property with their permission, it's not, you can't claim squatter rights because it's not hostile. You've got permission to be using the property. But yes, it can get, when you start getting into these, that's why it's so important to have these documents in place. And again, you have some control over what happens to your assets and your resources. A will, it can be changed at any time. Like I said, it never expires. But just make sure that you take it out and look at it every now and then, just to make sure things are still the way you want it. Now, if you have a trust, again, revocable trust, it can be changed. You can go back and change it. Life changes. Some of the things that you may have wanted when you set that trust up, maybe you don't want them anymore. Maybe the young children that you were going to provide for in the trust, maybe you've been blessed to see them grow to adulthood and they're responsible. And you say, I don't want to leave it to them in a trust. I can just go ahead and, leave it to them. I can put it in an account or something, or I could do something else, or I want to go ahead and give some of it to them. It's up to you, but you would, again, it's just up to you. It's basically, again, it's based on your knowledge, observation of your family and what it is you want to accomplish. If it's irrevocable, you can't go back and do that. Like I said, and just please, if you're leaving assets to somebody who's disabled, make sure that the attorney knows that so that you can do that in the right way, because you don't want to cause them to lose benefits. And they can derive a lot of benefit, though, from that. Now, the thing about the executor, we talked about the executor, the trustee, administrator. Okay, just taking notes. Okay, the administrator. Now, what happens during your lifetime if you reach a point where you cannot make your own decisions? Can your executor, trustee, personal representative, administrator, can they come in and do that for you? Right. The question's no. If you don't have a power of attorney, particularly with the administrator and the executor, their authority does not begin until after your death. They have no authority while you're living. You need, as was said, a power of attorney. Power of attorney is where you name somebody to handle your day-to-day affairs for you in case you ever reach a point where you cannot. There are basically two types. You can do what's called a immediate power of attorney. That means a person can start handling things for you immediately if you want them to. Or it can be a springing power of attorney. And that means you've got something that says this power of attorney shall not be effective until there's a letter attached from my doctor saying that I'm in need of assistance, or in their opinion, I don't have the capacity to handle my own affairs. It's up to you, whichever one you want. Now, when you make a power of attorney, it's a shared grant of authority. When you make a power of attorney, you don't give up any rights. You're just saying, I want this person to be able to make decisions, but I still want to retain the right to make decisions too. I say that because a lot of times people have a misunderstanding about power of attorney. And they think, well, the power of attorney gets to make all the decisions. That person is there to assist you. And it's not only a shared grant of authority, it is a voluntary grant of authority. You have to voluntarily give a person power of attorney. I can't tell you how many times people would come in and say, I need to get power of attorney over my grandmother. I said, no, you don't get power of attorney. Right, his grandmother, you don't get power of attorney over grandmother. Grandmother can come in and tell me she wants to give you power of attorney. And even when she does that, she still has rights to make some decisions. And just like grandmother gives, grandmother can take it away if you're ever doing things the way that she does not want you to do them. When you make a power of attorney, the standard is, what would this person do for themselves? How would they handle things themselves? And that's how you should handle things. And when you name your power of attorney, number one, first and foremost, it has to be somebody you can trust. I'm a big fan of powers of attorney. I think they're so important. It can keep you out of court. It allows you to have some say over who's going to manage or assist with your affairs if you can't. But I will tell you, you are giving that person a lot of authority when you give them power of attorney. You can write a check, they can write a check. You can sign your name, they can sign your name. So first and foremost, it's got to be somebody you can trust. And as important as powers of attorney are, I say, if you don't have anybody you can trust, then you're better off not doing it. Not doing it. Because even if you can come back later and cancel it, which you can, they can do a lot of damage before you cancel it. And so make sure it's somebody you can trust. Also, make sure it's somebody who is able to serve as your power of attorney. and make sure it's somebody who's willing. When I say willing and able, I always tell people, if you ask me to be your power of attorney, and I go, okay, I guess so. I just got to squeeze that into everything else I got to do. Do you want me as your power of attorney? No, because I'm probably not going to do a good job. Yeah, and that goes back to that earlier when I was saying, ask them to. Don't just name them. How would you like finding out surprise? You're your neighbor's power of attorney. Woo, didn't know that one. Okay, and it needs to be somebody who's able. And I would tell groups, you might have somebody you can trust with your life. You might have somebody who's willing, but everybody doesn't have the capabilities. And I said, you don't want to name somebody to be responsible for paying your light bill and they can't remember to pay their own. You'll be in the dark. So again, trustworthy, willing, and able. And always make sure you check with them. And I know we're getting close to the end, but I'll never forget, I had a person come in one time. Some things you can't make up. And nice lady. Sometimes people don't, everybody doesn't have close family or people around. So I was like, she's like, I want to do a power of attorney. I said, okay, that's a good thing. Who would you like to name? Do you have anybody you can name as power of attorney? She's like, well, not really, but I met this real nice lady in the grocery store a few days ago, and she was so nice, and she's willing to do it. And I'm like, no. I said, she could be a very nice person, but this is somebody you just met 3 days ago. I can't tell you what to do, but as your attorney, I can advise you. And I'm probably not going to be the one to draw that up because, again, it's a very important decision. And just make sure you got somebody you can trust. You can always cancel it at any time if you decide you don't want one. What happens if you don't have power of attorney and you get to the point where you can't make your own decisions? Then that's when you're looking at guardianship a lot of times. And when you put guardianship and power of attorney side by side, I do this on a chart, a comparison chart. Power of attorney is voluntary. Guardianship is not. The court makes the appointment. Power of attorney, it's a shared grant of authority. You get to still make decisions. Guardianship, conservatorship is not. That guardian conservator makes all the decisions. Power of attorney, you can cancel it if you ever decide you want to. Guardianship or conservatorship, nope, the court has to cancel it. So again, most of the time when a person has a power of attorney, you don't get into guardianship and conservatorship, and that's a good thing. But even if you have to, under that rare occasion where you have to get a guardian or conservator, you can say in your power of attorney, if by any chance I ever need a guardian or conservator, this is who I want. So you still have some control over it. Otherwise, anybody could go down and ask to be your guardian or conservator. It could be that oldest daughter who's controlling and bossy and who never did anything you wanted her to do. She could go down and ask the court to be your guardian or conservator over the son that always that you trusted with everything and helped you with everything. They're both your children. So the court would decide. But again, if you've nominated somebody in a writing, then you still have some say and some control. And not only for financial, but for medical too. You can have name someone as in a medical directive, somebody to make medical decisions for you. If you cannot, that's very important. You want somebody who, number one, understands what your wishes would be. And number two, who would carry out things and do things the way that you want them done. And again, it comes back to knowing your family. Some people have one child on the financial. This is the child that has the business background. They can manage money and dollars. But this other one is the one that takes me to the doctor. And it helps me, with my medication. They may want to make that child the medical power of attorney. You can do that. And then you can make somebody, you always want to have an alternate as well. Even if it is a husband and wife, you still need to have a power of attorney, even if you're just naming each other. You are not automatically, your spouse is not automatically your power of attorney. And a lot of times you'll see, because you do everything together, but there may be some things, although you can handle a lot of things for your spouse, there may be some things you cannot handle without a power of attorney. And when people would come in and they'd say, well, I want to make my kids the power of attorney, I would say, well, do you want your spouse first? Well, yeah, of course I want my spouse. Yeah, I want my spouse to make the decision. I say that's important because one time I saw a situation where the couple came in and they said they wanted their children. I said, okay. And this was pretty early in my career. And so they named the two children. I mean, family got along fine. There was no animosity or hostility. But then the wife got sick and she was in the hospital. And when decisions needed to be made, the doctors were bypassing the husband going to the children. And he couldn't understand. It's like, but wait a minute, I'm her husband. Like, yes, but they're the medical power of attorney. We have to ask them. Now, fortunately, the kids worked with, they brought him into the conversation. But could you imagine that they're going past you as the spouse, going to the kids? Fortunately, she recovered and they were able to correct the situation. But it wasn't anything malicious. It was just an oversight. They just assumed, well, of course they're going to go to my spouse first. So just keep that in mind when you're having these documents prepared. And then you have your advanced directive for healthcare, also known as a living will. That's another thing it's good to have. That is one of those things that there is a form that you can print off and fill out. And that form, it's from the state of Alabama form. It is great. It's perfectly fine to use that. It does not have to be notarized, just witnessed by 2 people. That makes it a lot easier for people to get it and to get it witnessed. And there's certain people who can't witness it. It can't be, which is like, right, it can't be witnessed by anybody who's related to you by blood marriage or adoption. Can't be anybody who will inherit from you at your death. It cannot be anybody who has a direct obligation to pay for your health care. In other words, anybody who has an interest in hastening your death cannot witness it. Anybody else can, and for obvious reasons, of course. You don't want to be pull the plug. Yeah, we advanced directive. And the advanced directive, it's actually the first part is a living will, and the second part is where you can name a proxy to assist with those end-of-life decisions and to make sure that your wishes under the living will are carried out. You don't have to name a proxy. You can if you want to. And the forms for Alabama power of attorney, durable power of attorney, there's a form too for that. And it's good. It's something, again, the legislature is approved. I like it because there's also like a couple of pages at the end that tells what the responsibilities of the agent are. Because a lot of times people don't know. You can ask them and they'll say, I'll be your power of attorney, but they really don't know what their responsibilities are. So that's good. You can use that one. And that form is actually on the TARCOG website where I used to work. If you go to, you see?
I was about to just follow up after you finish.
Oh, no, go right ahead.
The last time you were here, on our website, on the Steadfast website, and under the resources tab, all the link to TARCOG is there, the advanced directive is there. And also, you can get those living will forms when you go to the emergency room at the hospital.
Yes.
Like that, they have those forms too.
They will gladly give them to you. They like for you to have those because it helps them when decision making comes, and for liability purposes too. They like to have those. So that's great. And that TARCOG link, I will say, they offer all kinds of services. I mean, great services. I was listening to the speaker earlier, and one of the programs, we have a caregiver support program. They do things for grandparents too. It's not just elderly or older people, care recipients, but they have programs for grandparents who are raising grandchildren. So if that's still there, you can go just click on it, go under serving people, and you'll see legal, and then have a link to those forms. And you can print those forms out. Power of attorney has to be notarized but not witnessed. Advanced directive has to be witnessed but not notarized. But you'll see it when you print it off. But again, those are just some great resources that you can use. And the last thing I'll close with is bank accounts. I always like to talk about bank accounts when I talk about power of attorney. A lot of times we will put people on our bank accounts. And when you ask, why are you putting somebody else on your bank account? The answer is always, well, I want somebody to be able to pay my bills in case I can't. That makes perfectly good sense. Who doesn't want somebody to be able to pay their bills? But what you have to be careful about is when you put somebody on your account and it is a true joint account, your money is their money. That person can write a check just like you do, with your permission, without your permission. They can take out money just like you can take out money. And it doesn't matter if they ever put any money in. They can draw out every penny. And so that's important to realize. And the other thing is, even if that person would never take any money, have I seen it? Unfortunately, yes. I've seen it happen. Fortunately, I didn't see it. More people didn't take money than did, but I did see it happen a few times. And it was very sad when it did. But even if that person that you've named would never take any of your money, you have to be careful because there could be circumstances that arise which are beyond your control. They may not take your money, but what if they get sued? Your money's their money. Their creditors can take it. Did I see that happen? Yes. One lady called our office. She was very upset. She was on the bank account with a family member. She was only on there to pay bills because the family member wanted to be able to pay bills. She got sued. All the money was the family member's money. The creditors took all of it out. And she kept saying, but it's not my money. It's not my money. It was not fair. They shouldn't be able to do that. But they could. What if that person you listed files for bankruptcy? What if they file for divorce and the divorce court wants them to list all their assets, everything with their name on it? Your bank account could suddenly be part of a divorce proceeding. What if that person, any of those things can happen. So again, just as a safety precaution, what I'd always tell people is you can accomplish the same thing by doing a power of attorney, financial, and a POD that we talked about earlier. The power of attorney allows you to name somebody to access that bank account and handle other financial matters beyond the bank. But that person doesn't have they're not on the account and they don't have any ownership interest in the account. So if they got sued, their creditors can't take that money. They can't just, they're a fiduciary. They're held to that higher standard we were talking about. And then the POD, the pay on death, says after your death, that money is paid directly to them. But they don't own it while you're living. They can't just go and say, well, I want this money. Or if they get sued or file for bankruptcy or anything, it's not their money yet. It's not their money until after your death. And you can always change the POD if you wanted to, at some point later. But again, if you do the power of attorney and you do the pay on death provision, then you basically accomplish the same thing as putting a person on your account without the risk. And the thing about getting a person off your bank account, generally, they have to agree to come off. I've had people go through that. They want to take somebody off the bank account, but the person has to agree to come off. Yeah, you both have to go in there. If they won't agree, I just tell them that, well, you can basically just go in and draw all the money out and close the account and open you a new one if they won't agree. But again, and I'm not saying that because I want you to distrust your children and run out and take them off your bank account. I just want you to understand what it means to have true joint ownership, because a lot of times that is not explained when you set the account up. So I'll wrap up there. I know y'all probably ready for lunch. I thought I saw somebody with an apron on looking in. I don't know if that's y'all's lunch or not. So I guess that's my cue. Yeah, that's my cue. Where are they? Lunch is ready. But thank you for inviting me out. I hope that some of this information was helpful. And I'll stick around for a little while. I don't know what my Act 2 is going to be yet, but I was listening to your previous speaker, and she has 38 years. I was like, wow, that's amazing. I did 25. But, I also, I love what I did. It was a blessing to be able to do that for 25 years. But then you also know God will let you know when it's time for you to move to something else. And he let me, I wasn't expecting it. I didn't see it. But once he communicated that with me, he just kept confirming it. And so I don't know what my next step's going to be. I'm still praying about that, asking him what direction. It might be something completely different, but I trust that he's going to lead me where he wants me to go. And I'm thankful that he led me here today. And so I'll stick around for a little while if anybody has any questions. Okay. Thank you.
Thank you very much, Sister Rhines. We appreciate you very much, and we can't thank you enough for being here and sharing with us. So that is a very important part, and we just can't thank you enough. God bless you.
I just want to ask her one question. Do you have any cards or anything, or will we maintain that contact information?
I don't have any cards because I haven't actually started practicing again, but what I'll do is I will make sure that that Mother Madison has my email address and my phone number in case anybody just has like a quick follow-up and say, what was that, where was it, anything like that. But I'll make sure she's got that. I think I sent her something, but I'll make sure she's got the updated information.
All right.
Thank you very much for that. So I've known Sister Rhines for a very long time. We go back to Indian Creek. We came from Indian Creek Primitive Baptist Association when we were very young. So we were in the cabinet together. So God bless you. We love you. So we're thankful for you. Right now it is lunchtime. Let us say a prayer if you allow us to, and you consider yourselves dismissed. Let us pray. Our Father who art in heaven, dear Lord, we just thank you for this day. We thank you for Sister Rhines, and we thank you for Sister Carter, dear Lord. Lord, we ask you, Lord, to bless it and allow us to apply it however you see fit, dear Lord. Lord, we ask you, Lord, to bless Sister Rhines and Sister Carter in their next steps, dear Lord. Lord, we ask you, Lord, please allow your Holy Spirit to amplify so they don't miss a beat in all that you would have for them to do. And Lord, we ask you, we pray great blessings upon them, dear Lord. Lord, we ask you, Lord, to bless this food. May it be used for the nourishment of our bodies. In the precious name of Jesus, we pray and we thank you. Amen.
Amen.